Konga and the committee for making these reports, and also join the Honorable John Kiarie for thanking Madam Speaker as the predecessor of the chair currently for a very good job done in the 12th Parliament, because it set a very good basis for what they are doing now. Madam Speaker, like the Honorable TJ has said, we are constantly learning, and I would have the benefit of learning from my senior Otiende&Oluoch on whether the House actually has no role in lawmaking. My respectful view is that all lawmaking pursuant to Article 94(5) belongs to this House, and that all other persons who exercise that role only exercise it in delegated format. They only exercise it in that format, and it does not mean that they become the lawmaker. The lawmaker under 94(5). Thank you, Senior Counsel. So I proceed to my main point. Madam Speaker, the role of the delegated committee, it plays a very important role in terms of checking the entities of government, including cabinet secretaries, board chairs, all of whom exercise that delegated role of subsidiary legislation, especially when they exercise it to make bad law, which, unless it comes to this House in a negative format, where now the delegated committee has to make a recommendation for annulment, would otherwise become law. I have heard the distinguished chair, Honorable Chepkonga, say that the delegated committee brings regulations for annulment only as a last resort, and even after begging the cabinet secretary to amend, that is when they bring it. That is very absurd, and I'm not saying absurd because I disagree with the chair. Absurd because under 94(5) we are the lawmaking organ, but yet we have to beg a cabinet secretary, please relook this and bring it back in an acceptable format. It is for this reason, Madam Chair, that I think that the Statutory Instruments Act and our standing orders need to be relooked. And I think the Honorable Horan Bayer sits in the committee that I sit of, House Rules and Procedure. And Madam Speaker, who has just vacated the chair, who chairs that committee, we have accepted a recommendation that I placed, that we amend the Statutory Instruments Act and we amend our standing orders to require that all regulation, whether affirmative or in the negative or in the positive, must find their way to this House, either by way of a report, so that this House may be able to stamp its foot of authority and say, proceed or do not proceed. That is the only way we can affirm our role under Article 95, 94(5) and 95 of the Constitution. Madam Speaker, I also say this in light of provisions of the Constitution, which I hope at some point we will be able to relook. Under Article 115(7), we allowed, and the Honorable Otiende&Oluoch was there, will give us the benefit of what was the reasoning, allowed the President to make law and act as a lawmaker through the back door by allowing what you call presidential reservations. So that when you cannot raise the 2/3 requisite as a House to disagree with the President, that provisions become law. It should be the other way around. When we pass a law, the President should raise 2/3 to disagree with us. That is when we will exercise the supremacy of this House. And we borrowed the model of the US presidential system. And the US presidential system has said, time without number, and I just want to quote, the Supreme Court of the United States, Clinton versus New York, where it said that line veto amendment is unconstitutional. You cannot allow part reservations or line amendment of a law that we have made.
Honorable Anthony Oluoch, we have would you like to be informed by the Honorable Otiende&Oluoch?
Thank you.
Would you like to be informed?
Thank
Okay,
you. Thank you, Honorable Oluoch. Madam Speaker, I wanted to invite to inform Honorable Oluoch on two issues. One is in respect of what he sought my concurrence on. And indeed, I agree with Honorable Oluoch, and Honorable Owen Baya is wrong. Under Section 70 of the Universities Act, the power to make regulations is for the Cabinet Secretary. It is the Cabinet Secretary who must propose those regulations, then bring it to the Delegated Legislation Committee. It is not for the Delegated Legislation to generate them. It would be unconstitutional. And that's the first information.
Honorable Otiende&Oluoch, I know you are very smart, but are you informing the Honorable?
I'm informing the Honorable
member for Madare, or you are informing? I'm
informing the member for Madare because he concurred.
Deputy majority.
He had concurred with the majority, with the minority deputy whip. Anyway, the second information is to Honorable Oluoch. In truth, the Constitution does not allow the President to make any law. The Constitution allows the President to make reservations to any law that we have passed. The bad practice that the presidents have had of proceeding to amend the law and present it is not in tandem with the Constitution. So do not blame the Constitution, blame the practice, and blame us as a House who allowed that to happen. Thank you.
Well, I hope that, just for neatness, I hope that the information that you have been given by the Honorable Otiende&Oluoch enriches your debate. What is out of order, Honorable Baya?
Mentioned me. I would like to just to say, I agree with...
so now what is out of order, Honorable Baya?
What is out of order is that he imputes improper, that I do not know what Section 70 says. I know what Section 70 knows, and I'm alive to it. And I know that the minister is supposed to make you regulations. Yes, that I know. But I also know that if the minister fails to make regulations, this House can stamp its authority and make law in the main law, and not just subsidiary regulation. That can be done, and the Committee for Education can do it. So he should not think I know. Only he needs to be... Thank you.
Well, thank you very much, Honorable Baya. This is a house of debate, and he has gotten an opportunity to stick to what he had said. So, Honorable Member for Madare, please proceed, conclude.
Thank you. Thank you, and I thank the Honorable Otiende&Oluoch for that information, that the reason that I was bringing the Clinton versus New York case was to demonstrate that what they said, that when you cherry pick a particular line in a proposed legislation sent to you for assent and proposed amendment, that which they call line vetoing was said to be unconstitutional, and to the extent that we have that provision in our Constitution that allows a similar mischief is unconstitutional. And I say it overall in the context that we cannot allow ministers and other entities to use the avenue of regulations to stick in things that are unconstitutional and go contra to our powers under Article 94. So I support the committee. Thank you very much.
Thank you very much, Member for Madare. Honorable members, I would like to acknowledge, seated in the public